Good morning, everyone, and welcome to the third and final webinar in our Planning Law Update for Local Authorities series. This one's going to focus on planning challenges. It's great to see so many of you joining us today, and I hope that you'll find the discussion useful. I'm Heather Sargent, and I'll be chairing the session, joined by my Landmark Chambers colleagues, Alistair, Luke, and Kim. Before I introduce them to you formally, let's just deal with a few housekeeping points. Your microphones are automatically muted, so you don't need to worry about muting yourself. We are going to try and answer as many questions as possible at the end of the session. So if you have a question for us, then please do submit it by using the Q&A function in Zoom, which should be either at the top or bottom of your screen. We're recording this webinar and we'll send the link out shortly after we finish this morning. And the final housekeeping point is that if your connection does drop at any point, then you should be able to rejoin using the original link again. So turning to this morning's speakers. First, we have Alistair, who's extremely well placed to speak to us about the interpretation of planning policy. He's the author of the very helpful book, Interpreting the Npbf, the New National Planning Policy Framework, which was published in 2018, and he's also the editor of the Npbf Digest. He's been in a number of important cases on the interpretation of policy, so including Red Hill Aerodrome on Greenbelt policy and City and Country Bramshill on isolated dwellings. And Alistair undertakes a lot of work for local planning authorities, including in relation to the promotion of the County Durham plan. We then have Luke, who practices across the full spectrum of planning, property and local government law. In planning, he has a busy local authority advisory practice, and he appears regularly in inquiries, examinations in public and in the planning court. And he has a particular interest in built heritage issues, which is what he's going to speak to us about today. And he's appeared in a number of heritage-focused inquiries. And then we have Kim, who joined Chambers following successful completion of pupillage in 2019 and is building a practice in all three of Landmark's main areas, but she has a particular interest in planning and property and the crossover between those two areas. Kim is developing a varied practice covering all aspects of planning, environmental and infrastructure law for both local authority and developer clients. So I am now going to hand over to Kim, who's going to be speaking to us about bringing and defending High Court challenges.
Thanks very much, Heather. As Heather said, I'm going to be talking today about bringing and defending High Court challenges. Now, while local planning authorities are usually involved as defendants to High Court challenges, there are cases where they're also involved as claimants, and we'll maybe see a couple of examples of those as I go through the talk today. This is obviously a huge topic to cover in just 15 minutes. I could do an hour presentation on many of the points that we're going to be looking at on their own. However, it's intended to be a quick overview of some key points to be aware of, and maybe a quick run through a few very recent cases just to get an idea of what's happening in the planning court, or what's been happening in the planning court over the past couple of months. So in terms of what I'm going to cover today, we're going to be looking at routes to the High Court. So how do you get there in the first place? Time limits, costs, remedies, and then a few, like I say, a few recent decisions from the last couple of months. So in terms of routes to the High Court, one route, which I'm sure many of you will be familiar with, is traditional judicial review route. Now that's going to be open to people who are looking to challenge a decision to grant planning permission, for example, but also challenges to neighbourhood plans under Section 61N of the 1990 Act. However, the Planning Acts restrict the mode of challenging the validity of a lot of decisions taken under the Planning Acts to so-called statutory challenges, which are closely prescribed by the statute itself. So that's particularly Section 284 and 285 of the 1990 Act have that effect. So a lot of the decisions that are being taken under those acts can only be challenged by statute, and that's via the statutory challenge route. And those challenges are under, for example, Section 288, which I'm sure everyone will be very familiar with because that's the means of challenging a decision on a Section 78 appeal. Section 289 for enforcement appeals, 113 of the 2004 Act, for example, against local plans, adopted local plans, and Section 287, which is perhaps less familiar, but that's a route for challenging simplified planning zone scheme decisions and a couple of other things, but that's less frequently used. Finally, I just wanted to touch on another way in which a local planning authority may end up in the High Court, albeit not not through judicial review, is on an application for an injunction. And for example, the case that you've got there on the screen, the Chelmsford County Council case, was the local planning authority seeking an injunction against works being carried out at a caravan park on the basis that it fell outside the scope of a planning permission that had been granted. So while the rest of this talk is going to focus on judicial reviews or statutory challenges in the High Court, I just wanted to note that that is another way into the that you may end up in the High Court as a local planning authority. And there are lots of issues there in terms of overlap between property and planning law and public and private law considerations that are interesting, but maybe one for another webinar on another day. So if you have ended up in the High Court, albeit as a defendant, or you're considering bringing a challenge as a claimant, my number one top tip is to download and have a read of these two documents. The first one is Part 54 of the Civil Procedure Rules, and in particular Practice Direction 54E, which deals with planning judicial reviews, and the Administrative Court Judicial Review Guide, which is a really fantastic document that will guide you through a lot of the key procedural points to bringing and defending claims in the High Court. And there's some helpful information about listing policy of the Planning Court in particular at page 125 of that document. So that's your starting point, really. So moving on to the first sort of topic that I wanted to cover, which is time limits. As many of you will, I'm sure, be aware, there is a there's a 6-week limit for judicial reviews, for planning judicial reviews, that's imposed by Rule 54.5 of the Civil Procedure Rules. However, there is judicial discretion associated with that 6-week limit, and that's quite clear from a very recent decision that's just come out on Friday of this Friday just passed, of the Croyd Area Residents Association and North Devon case. And it's worth just talking about that case in a little bit more detail because it does raise some interesting issues. This is a decision of Mrs. Justice Leven, and Heather actually acted for the interested party in this case, so she'll be much more familiar with it than I am, but I'm going to just go through a little bit of some of the points that arose. And now this was a challenge to a planning permission that was granted in 2014, so you can immediately see that there are some time limit issues here. And that was a planning permission for a holiday park in an AONB. And it was granted following an application for an extension of the time limits for which the holiday park could open. However, when it was granted, it mistakenly, the new permission mistakenly referred to a plan, but seemed to include a much wider area than had ever been used for the holiday park itself, or for stationing caravans and camping as part of the holiday park. And it had never been intended to be used for such purposes. That wasn't the point of the application that was made. All the parties accept that. However, given that the permission was granted, some 4 years later, the interested party wanted to start developing that land and using it for the caravan park. So first of all, they tried to get permission to do that because they didn't think that the 2014 permission actually gave them permission to. However, that failed. And then they realised, well, we've got this 2014 permission that actually refers to this wider area. Let's get a lawful development certificate that says that we can use it. That was refused by the local planning authority, but allowed on appeal by the inspector. So at that point, the interested party had the right to start developing that land, and the claimant decided to bring a challenge to the 2014 permission itself that underlay the lawful development certificate. Now, it was accepted here rather unusually by both the defendant, local authority, and the interested party that the 2014 permission was unlawful and should never have been granted. However, the interested party were arguing that it should not be quashed because this challenge was very, very, very out of time. And the first point that arose really in this challenge was the interaction of sections 284, which I mentioned, 288, 192, and 196, and those are the provisions concerning lawful development certificates, and whether there was a statutory bar actually against challenging, first of all, the lawful development certificate, but the permission underlying it, more importantly. And Mrs. Justice Leven said, well, actually, there isn't a statutory bar because whilst Section 284 debars any challenge to the lawful development certificate itself outside of the regime given in the Act, it doesn't preclude a challenge to the planning permission on the basis of which that certificate was granted. That is governed by general judicial review, of course, a 6-week period in the Civil Procedure Rules, but that's a period imposed by procedure rules rather than the statute itself. And interestingly there, Mr. Justice Leaven said you have to take a cautious approach to extending a statutory limitation on challenge, as is given in section 284, to a different legal order, namely in this case the planning permission itself. So that led on then to a discussion about discretion and extensions of time in normal planning judicial reviews, and consideration of a Thornton Hall case, which you may have come a Court of Appeal decision, which you may have heard of, which did extend, and where the court exercised its discretion to extend time. And there was, while this was a 6.5-year delay, there were various phases that the court had to consider, some of which there were better reasons for the delay than others. But essentially, Mrs. Justice Leaven tried to weigh up all of the circumstances and found that the overriding factor here was the harm that would follow from upholding the 2014 permission, namely to the AOMB. This permission would never have been granted had they realised that that's what they were doing, had the LPA realised that that's what they were doing. And that taking all of the relevant factors into account and applying the Thornton Hall decision and a case called Gerber, she considered this to be an exceptional and unique case in which it was appropriate to extend the time and to quash the 2014 permission, albeit 6 years down the line. And one practice point I just wanted to pick up from this case, and while this has not been finalised yet, is that the local planning authority conceded very early on that the 2014 permission was unlawful and didn't participate, therefore, in defending the proceedings at all. And strategically, that was probably a good move because, at least from a cost perspective, they've probably provided themselves some protection there, albeit that's yet to be determined. So that was a bit of a foray into just that case on judicial review limits. And what's to be noted is that statutory reviews have very strict time limits that are imposed by the statutory provisions themselves. A lot of those are 6 weeks. They're not all. Do check the statutory provision that you're dealing with. And that there won't be that discretion then to depart from those limits. So that's very important to comply with them. So moving on to costs, having just mentioned it briefly, sorry. What you're normally dealing with is the court's general discretion to award costs. That's the starting point. The court doesn't have to award costs. It has a discretion. That's under Part 44 of the Civil Procedure Rules. And there's a general rule that the loser pays the winner's costs, as I'm sure you'll all know, at 44.2. And the court has to have regard in exercising its discretion to all of the circumstances, including the conduct of the parties to the proceedings. In terms of the reasonableness of costs, only reasonable costs will be awarded. They have to be reasonably incurred and reasonable in amount. How the court assesses that will be on two different bases, either the standard basis where they'll look at whether the costs themselves are proportionate to the matters in issue. There's also then the indemnity basis where the court won't take into account proportionality, and that doubts about whether costs were reasonable will be resolved in favour of the receiving party. And assessment of those costs can be summary or detailed, far more provision than I can cover today in the Civil Procedure Rules about all that. However, what's been interesting in judicial review is what happens at the permission stage in relation to costs. Now, if you are a defendant and you and this is a key practice tip here, if you're a defendant who would like to be awarded costs at the permission stage, you need to be sure to include an application for costs with your acknowledgement of service and a schedule of the costs that you're claiming. But you'll be limited to the costs incurred in preparing the acknowledgement of service and the summary grounds of defence. In terms of the general principles that a court's going to be looking at with regards to awarding costs at the permission stage, those were established in the Mount Cook case that you've got there on the screen. And effectively, those principles are that if a defendant is successful at permission stage and you've filed an acknowledgement of service and any interested parties filed an acknowledgement of service, you should generally receive the costs of filing that acknowledgement of service from the claimant, whether or not you attend an oral permission hearing. However, a defendant who attends and successfully resists the grant of permission at an oral possession hearing will not usually recover the costs of attendance at that hearing, although you'll still be entitled to your costs of the acknowledgement of service. And those rules will only be departed from in exceptional circumstances, and those can include very hopeless claims, cases where the claimant has persisted in taking the matter, in bringing this matter despite being alerted to how hopeless the claim was, any abuse of process by the claimant, whether the claimants in effect had the advantage of an early substantive hearing, the resources of the claimant, and whether permission was refused at a rolled up hearing. Those are some of the factors that the court can take into account. Now, in terms of costs on settlement, this will normally need to be dealt with by agreement wherever possible, and the court's quite strong that you should be trying to agree these things. However, there's quite detailed guidance in the Administrative Court Guide that I've already referred to, and the Annex 5 to that guide has got some helpful guidance on this point. But in particular, you're looking at whether court, if you are ending up with a court making an order, then the general principles that get set out in the M and Croydon case. And I'm going to just skip through that because it's the way I'm conscious of the time, but that's a good case to have a look at if you are getting to a point of settlement on a judicial review and want to know how the court might deal with the cost position. Another thing to be aware of is the cost capping orders that are available, and those are governed by the Criminal Justice and Courts Act, and that will mean that you can impose a limit that the claimant can be ordered to pay in respect of the other side's costs, but it must be coupled with a limit on the cost that the claimant can recover from the defendant. And perhaps the most important cost capping order that you'll come across in planning cases are the Aarhus Convention costs cap, and that's for claims involving environmental issues, but following the decision in Venn, that's very, very broad, and it's broad enough to, arguably broad enough to cover most, if not all, planning matters. And this allows for a recovery against the claimant of £5,000 if they're claiming as an individual, and £10,000 otherwise. So if you've got an individual claimant that's bringing a judicial review, they're going to be very protected under the Aarhus cost cap. However, the costs that they can recover against a defendant are limited to £35,000. It was important to note that those limits can be varied or removed by the court if an application is made, and the court has to be satisfied that removing those limits or varying them would not make the costs of proceedings prohibitively expensive for a claimant. But it's something to bear in mind if you're against a claimant that does seem to have a lot of resources at their disposal, but that is an option that you can make that application to the court. If you're acting as claimant, then you would need to make it very clear that you're applying for an Aarhus cost cap on your claim form. So turning very quickly to remedies, there are the 6 remedies in judicial review that I'm sure many people, you'll all be very familiar with. They're there on the screen. Damages obviously are not going to be, damages aren't going to be available in every case. They're primarily a private law remedy, and there are various provisos in terms of when you'll be able to get an award of damages in a judicial review. So only if you're seeking another remedy, you can't just have a pure damages claim. And ultimately, the point to bear in mind here is that any remedy is at the discretion of the ordered at the discretion of the court. So even where the claimant has won and shown that the defendant's acted unlawfully, the court might still refuse to grant a remedy. For example, where there's been delay or that the error of law is not material to the decision that's been made, the remedy would serve no useful practical purpose, or there's been no harm suffered by the claimant. Furthermore, the court must refuse to grant any form of relief, including damages, if it's highly likely that the outcome for the claimant would not have been substantially different if the conduct complained of had not occurred, unless reasons of exceptional public interest exist, and that's the test at section 31 2A and 2B of the Senior Courts Act 1981. So I'm going to touch very briefly on a couple of recent decisions involving LPAs that you've got there on the screen. These are all from the last couple of months, and just show that the Planning Court has continued to be very busy throughout the pandemic, and there's a few interesting decisions that I thought I'd bring to your attention. The first one is an example of a claim brought by a judicial review brought by a local planning authority, and that was a challenge to the Secretary of State decision that land met the criteria for deregistration as common land under para 6 of Schedule 2 to the Commons Act. So that's another route to the High Court that wasn't mentioned in my first list, but another one to think about. The second is quite an interesting case on irrationality and the margin of appreciation that's awarded to local planning authorities when they're making decisions. And this was a case which is quite unusual in its facts, because it was a challenge to a decision of the local planning authority to designate a detailed emergency zone around an atomic weapons establishment. So not something that you come across every day, but the principles on the grounds of irrationality and how you bring in the irrationality challenge and the breadth of deference effectively that the court will allow to an authority who's operating in a regulatory regime and being advised by experts on a topic that the experts are going to have much more familiarity with than the court is quite important, and so worth having a read of if you're operating in a regulatory framework and making those kinds of decisions. Thirdly, interesting case in Finch and Surrey, where the BBC was actually held in contempt of court and fined a significant chunk of money, although probably not for the BBC, for broadcasting a remote hearing. Those rules still apply. Just because you're in a virtual hearing doesn't mean you should not be recording it, and you certainly shouldn't be broadcasting it. And that was quite a point made, I think, in that case by the court on a reference to a claim. Well, they were found in contempt of court effectively for doing that. And finally, there was a recent decision on variation of conditions under Section 73, which is quite an interesting topic following the Finney case last year, I think. And this was another case where the permission was quashed because it was found to infringe that Arrowcroft principle as discussed in Finney about newer conditions being applied on a Section 73 application being inconsistent with the description of the original permission that had been granted. And so that's quite another interesting one for local authorities to have a look at if you're looking at Section 73 applications. So that was a quick whirl through High Court challenges. I'm going to hand over to Luke now, who's going to talk about planning decision making involving heritage. Thank you.
Well, thank you very much, Kim, and good morning to all of you. I'm going to talk about heritage. Heritage is one of those subjects that for the last, at least 10 years has been one of the most prolific and successful means for members of the public, private parties, applicants, etc., successfully to challenge local authority planning decisions. So if there's one area that you really need to understand and get to grips to protect your decision making from challenge, it's going to be heritage, I would suggest. Now, what I propose to do is to start off by talking about some of the key concepts that exist in this area of the law. Heritage can, as a matter of policy, can be quite complex and quite difficult to grasp. There are a number of cul-de-sacs and false turnings that can be taken. And in my experience, those generally come from not quite understanding the conceptual targets of the policy and the law in this area. Once you understand those concepts, it's very much easier to navigate through the area. So with that in mind, I'm going to talk about 4 of those key concepts first. The first and perhaps most important is the notion of significance. Now, when you're talking about a listed building, say, it's easy to think that policy is aimed at protecting the building itself, in the sense of its fabric. But that's not quite right. If you read the policies and the law, which we'll come to later, what's usually protected is the significance of the asset rather than its fabric. Now, fabric can, of course, contribute to significance, but it's not the only thing that does so. There are a number of other things that can give rise to the significance of a heritage asset that have got nothing to do with its fabric. So it's worth bearing in mind, what are you actually safeguarding when you're applying heritage policy? The answer is significance. I've given you there on the slide the Npbf definition of the term. What Historic England tells us is that there are a number of aspects of significance you need to consider. Going through them briefly, first of all, the nature of the significance. What is it about the asset that gives rise to its sensitivity? If, for example, your asset is a historic shop, it may be that a very large part of its significance comes from its location in an area that is retail focused. It may have nothing to do with its physical fabric. It may be all about the nature of the uses that go on around it, for instance. The extent of significance importance as well. This generally ties into the ability of the building to be brought into a useful occupation or be put to some kind of economically viable use. its adaptability to change without losing significance is something that you need to think about here. The level of significance is an obvious one, really. You know, a grade 2 listed piece of street furniture in London is not of the level of significance of something like Hampton Court. You know, it's an obvious point, but it's a very important one. And finally, cumulative impacts are worth bearing in mind here as well. Historic England is clear that when you're thinking about significance, you've got to think cumulatively, not individually. The second concept, closely related to significance in respect of listed buildings in particular, is the notion of setting. Now, the statute, which we'll look at later, expressly protects not just the significance of the heritage asset itself, but also its setting. So you've got to understand what setting means. And I'm afraid to say it's rather a nebulous concept. It's quite difficult to define precisely what is included in a building setting. The Npbf gives us the closest we've got, which is it's the surroundings in which a building, the asset is experienced. Now, those surroundings can move and shift over time. You know, the surroundings in which an asset was experienced 50 years ago may not be the same as the surroundings in which it's experienced today, for instance. Historic England's got a very helpful note called Practice Note 3, which is all about heritage asset settings. And what that tells us, perhaps most usefully for understanding setting, is what setting is not. It's not the same as curtilage. It's not the same as landscape designation. It's not the same as area context, for instance. It's informed by all of those things, but you can't simply work out curtilage, say, and say, well, the curtilage must be the same as the setting. It's a discrete concept with a discrete set of governing principles and concepts, and it's got to be thought about separately and specifically. In many cases, the setting will be completely tied up with how the asset appears. If you're dealing, say, with an application that's going to impact on a listed church, then long distance views across the countryside to the spire of the church from an adjoining village, say, is going to be a key part of its setting. But it's important to understand that the test isn't how something is seen, it's how it's experienced. An experiential test pulls in all 5 senses. You know, it's not limited to how the thing looks. Sound and even smell can have an impact. And the Palmer case from a couple of years ago in the Court of Appeal confirmed that in that case, the very noticeable odours from a proposed chicken farm were capable of having an impact on the setting of a listed railway cottage a couple of miles away. It ended up not harming the cottage, but it was relevant. You've got to think holistically about setting in that sense. Third concept we need to talk about is harm. Now, harm and its categorization is essential for finding your way through heritage policy. Generally speaking, the level of harm that a proposal will give rise to an asset will dictate which policy route you have to follow through the Npbf and which policy test you have to apply to decide whether the application is or is not acceptable. Now, there are 3 categories of harm. There's none, there's less than substantial, and there's substantial. Of course, there are a huge number of ways in which a harm can fall within one of those categories. You know, something can be just short of substantial, or something can be barely more than nothing. Both of those harms would be less than substantial for the purposes of identifying the test you're going to apply. An important case from a couple of years ago called James Hall and Bradford established that there is no such thing as de minimis in this context. Even if you have a tiny bit of harm, that's less than substantial, and you have to follow the less than substantial pathway to making your decision. Now, that's a really important point in practice, because it's very common to get advice received when you're preparing your report to committee from heritage officers, which say, well, there's maybe a minimal bit of harm on this, or there's a very slight impact here, but we don't think it's too small, we don't need to worry about it. If you see that sort of advice, be on your guard, because you will probably find yourself having to treat the asset as harmed, even though it's tiny there. Now, I've mentioned already most of the things on this slide. The policy test is dictated by the harm categorization. But once you're working out, once you'll reach the point of deciding what the level of harm is and how to apply the test, those are matters of pure planning judgment based on the facts for the council as the decision maker. A very helpful case from only 2 weeks ago, actually, called City and Country Bramshill, which confirmed that, just how much this is about planning judgment. We'll come back to that later on. Finally, substantiality. What does substantial harm actually mean when you're trying to make your judgments? Well, this is again quite a nebulous, fact-specific question. The best we can do is the approach in the old Bedford case from Mr. Justice Jay, who said that harm's substantial where it would have serious impact on the significance, so that the significance is either completely wiped out or very much reduced. So that's what you're looking for. A loss of almost all of or all of the value of the asset, effectively, in heritage terms, will give rise to substantial harm. Anything less, you're into the lower category of less than substantial. Moving on then to the actual test and the framework. It's customary in these sorts of talks to start with the statute, and I've given you the statutory tests there because obviously they're important. But unusually in the heritage context, you actually in practice don't need to think too much about the statutory test. And that's because the approach in the Npbf has been to wrap up all of the content of the statutes into the Npbf procedure that's provided for. So that if you do what the Npbf says, by definition, you're almost certainly doing what the statute requires as well. And that was confirmed for the 2012 Npbf in the old Mordew case. The current 2019 Npbf has been modified to make that even clearer. So in my view, there's very little doubt that if you follow the Npbf, you're complying with the statutes. The development plan will almost inevitably have heritage-based policies in them, but once again, they will almost inevitably mirror the Npbf. So in substance, you're probably dealing with the same thing. As a tip though, when you're writing reports to committee, it's worth setting out that the statute and the development plan and the Npbf are all engaged, even if they all posit the same test. It's helpful to show that you're aware of them. You don't want to have to be implying thought about the statute when you can just say it. The Npbf itself then, the key driver for how all of this works, is worth a look. Section 16 is what you want. This is where you get the policy tests. And the overarching objective is there on the slide. It's about conserving the significance of assets, essentially. Now, the Npbf divides assets into two categories, which are called designated and non-designated. Designated assets are generally the big important ones, things like listed buildings, conservation areas, scheduled ancient monuments, a few others. They're listed in the Npbf glossary. Everything else that's of heritage importance is a non-designated asset. That has a slightly different test. Your starting point when you're making decisions about heritage is to work out significance. Now, the Npbf is clear that it's for the local authority to identify and assess why the asset is significant. The applicant's got to provide information to help you do that, but it's the authority's job, as I say, to determine the nature of the significance. And as we've seen already, once you know the nature of the significance, you can work out whether that significance is harmed, and if so, what the grade of harm is going to be. Paragraph 192 sets out 3 express considerations that councils have to take into account in heritage-based decision-making. Now, I'm not going to read them out, they're there for you on the slide, but there are, I would suggest, 2 key themes that emerge from those points. The first and most obvious is conserving heritage significance. That's obvious, you'd expect that to be there. The second focus of government policy, which is in some ways less expected, is this idea of making heritage assets useful to the community, to have them in some kind of economically beneficial use, or to have them contributing to the vitality of a community. The way I think about it is that the government wants heritage assets to be conserved in a live way rather than a dead way. You know, you're not taking an asset and preserving it in aspect, not allowing it to change, not allowing it to be useful. It's not enough to sort of fence it off and leave it there. You've got to integrate it whilst preserving its significance. And if you can do that, you'll be absolutely on point with policy. What are these tests then that have to be followed? There are essentially two routes depending on whether the harm is substantial or non-substantial. If it's substantial harm, you should refuse permission unless the harm is necessary to achieve substantial public benefits that outweigh the harm. That's the primary test. There's a secondary test about reusing otherwise unusable assets, but that's the one you mainly will be thinking about. It's a very high hurdle. It should be very difficult to get planning permission that involves substantial harm to an asset. And that's made clear by paragraph 194, you'll see above. Substantial harm, even to grade 2 listed assets, the lowest category, should be exceptional. If your asset is in one of the more important categories, it should be wholly exceptional. Hard to think of a more stringent policy test, really. If you're dealing with less than substantial harm, you're conducting a balancing exercise. You've got harm on the one side against the public benefits on the other. You weigh those two up and come to your decision. But it's important to realise that it isn't what we call a flat balance. The scales aren't starting equally with harm on one side, benefit on the other. Instead, the harm, even if it's less than substantial, even if it's small, has to be given great weight, considerable importance and weight in that balancing exercise. That's made clear by paragraph 193, and the inclusion of 193 is what brings the Npbf approach in line and foursquare with what's contained in the Listed Buildings Act. Just a few slides ago, I set out what the tests were. If 193 is applied to either 195 or 196, then you'll be complying with the statute effectively. Few bullets which I won't linger on about other kinds of assets. For non-designated assets, it really is a straightforward balance between benefits and harms, bearing in mind the objectives of heritage policy we talked about earlier. And in conservation areas, generally speaking, you are applying the same test as for listed buildings, except that it's fairly rare you'll be losing the whole of a conservation area. They tend to be quite large, as you all know. Rather, what you're looking at is the impact of losing the element or elements that make a positive contribution to the significance of the conservation area. In practice, the test is very similar. You've just got to approach it through a slightly different way of thinking. How then do you conduct this balancing exercise? How do you weigh up harms and benefits? Now, in the City and Country Bramshill case a few weeks ago, I mentioned Lord Justice Lindblom was absolutely clear that this is a matter for the planning judgment and discretion of the local authority. How you identify the benefits, how you identify the harms, the approach you take to weighing them are all matters of planning judgment. And the reason for that is because this is such a case-sensitive area. There are so many ways in which the test might manifest. And Lord Justice Lindblom gave the example here of the numerous ways in which the balance might resolve, the various types of considerations and how they play out. Very, very fact sensitive. Now, that is why the focus here is on planning judgment and on deciding what to do case by case. How do you evidence the balance? Final set of things I'm going to talk about. As I've mentioned in the old Mordew case, generally speaking, if you follow the section 16 tests, you'll be okay, you'll be in compliance. It's good practice, though, to mention all of the bits of section 16 you've thought about and the way you've thought about them, as well as how they map onto the development plan and the statute. And this is such a common area of challenge, and it's such a fruitful territory for someone who wants to overturn one of your decisions, that it's well worth taking the time on this section of your report and getting it absolutely right. As to how this can go wrong, I'll finish with a couple of cautionary tales for you, both from the last year. The first is the WF Price case. Here, the reports committee set out paragraph 196 and the less than substantial balancing exercise, told the council that's what it had to do. What it didn't tell the council, the committee, to do was to give great weight to the harm within that 196 balance. And as we saw before, if you read 196 in isolation, it can look like a flat balance. It's 193 that tells you that it's not. So you've got to make sure you set out all the relevant bits and apply them to avoid falling foul of the YF price approach. Finally, the Liverpool case, which is from earlier this year, held that a decision was unlawful where the reports committee didn't mention objections from its own heritage conservation team. Slightly more obvious point, that one, but nevertheless, it's worth reiterating. In the field of heritage, if there are objections, set them out in the report so that it's all fairly and squarely before the decision makers. That doesn't just apply, of course, to objections from your own heritage team. If there are heritage objections from interested parties, from local groups, for instance, set those out as well so that the council can be sure to pull everything in, looked at it all in the round. Well, that concludes my talk on heritage, and I'll pass you on to Alistair, who's going to finish by talking about policy interpretation. Thanks very much for listening.
Well, good morning, everybody. I hope that you're well. Happy spring after the vernal equinox over the weekend. It seems an awfully long time since last spring equinox. I'm sure we've all learned a huge amount about, remote working, remote webinars, all of these things. I was reflecting this morning that one thing that I haven't learned in the last 12 months is how to avoid one's head looking incredibly shiny when you have lighting from above on a webinar. So I'm afraid we're just going to have to live with that. That is something I failed to learn in the last year. Hopefully we might learn something, or at least be reminded of something, or find something useful in the next 10 minutes or so in relation to the interpretation of planning policy. What am I going to talk about? Well, as a quick overview, I thought we'd have to think about, well, who does what? Who has what responsibility in terms of the interpretation of planning policy? Then we might have a look at some general principles of interpretation, if I can call them that. Then let's distinguish between development plan policy on the one hand and the national planning policy framework on the other hand. And then finally, I'll look at some practical tips. I know the overarching topic for this webinar today is about High Court challenges, and that's been relevant to what both Luke and Kim have been talking about. That said, the issue of the interpretation of policy is relevant in writing reports to avoid High Court challenges, but also in terms of appeals, whether they're by written reps, hearings or inquiries. The interpretation of policy will be relevant to that. So even regardless of the High Court context, this topic is an important one. It is, however, it must be said, one which has given rise to a very large number of court challenges over the years, particularly since 2012, for reasons which I'll give. So it is, as with heritage, it is a potentially quite a litigious topic. And therefore one which is particularly useful for local planning authorities to be aware of. So in terms of our first question, who does what? Who has what responsibility? Well, in terms of officers writing reports so as to justify a delegated decision, or indeed to assist the planning committee, it may well be necessary for an officer report to decide what a policy means. And likewise, planning inspectors, when they are carrying out an appeal, they will have to give a view on what policy requires. That quite simply is just a function of decision making. If a decision maker is saying, well, is considering how a set of facts, how an application, how a proposed development fits within the policy framework, then they will have to, at least at some level, have a view as to what that policy framework requires, what that policy framework means. So at the ground level, that will be a necessary role for both officers and for planning inspectors. That said, planning inspectors and officers don't have the last word on the interpretation of policy, and indeed the courts have made it clear that it's not enough, for generally speaking, for a decision maker to reach an interpretation of policy which is a reasonable one. It has to be the correct one, and lo and behold, who decides whether or not the interpretation of policy is correct? Well, it's the court. There are some exceptions to that. For instance, where the terms of a policy itself are vague and clearly require an exercise of judgment. There, a decision called Gladman suggests that it might be enough for the decision maker to reach a reasonable interpretation, but the starting point is the interpretation of policy as a matter of law, and that comes from the Tesco and Dundee case. And that is why I said a few seconds ago that it's since 2012 that this has been a particularly fertile ground of challenge. If an objector, in the field of judicial review of the grant of planning permission, or a disappointed developer challenging a decision of inspector under section 288 of the 1990 Act, if they're trying to bring a challenge which has to be on grounds, essentially on grounds of law rather than just grounds of judgment, then one of the bases on which they can do so is to challenge the interpretation of policy reached by the decision maker. As I said, it's the court's view of the interpretation of policy which is conclusive, not the views of the author. As was said as Lord Justice Sullivan said in the Red Hill Aerodrome case, it doesn't matter. It's not a question of what the Secretary of State wanted their policy to mean. It's a matter of what the policy actually means. That said, the court does sometimes find the views of the authors of policy to be relevant. So in the Watermead Parish Council case, the Secretary of State was not a party. In that case, it concerned the interpretation of the Npbf, and there the Court of Appeal was aware in deciding that they didn't have to reach a conclusive view on the interpretation of the framework. They were aware that the author of the framework wasn't there to give submissions in relation to his own view. Then in the East Staffordshire case, when the same question arose and did have to be resolved, the Court of Appeal noted, oh, well, we actually have the Secretary of State represented this time, and that was a clear advantage. The interpretation of policy as a matter of law, the application of policy to the facts of a particular development, that is a matter for the decision maker, subject only to review on irrationality grounds, that sort of basis of challenge. How do you draw a distinction between interpretation of policy and the application of policy? Well, I think that's a difficult question. Mrs. Justice Leven in the Wiltshire Council case suggested that where a question is capable of one objective answer, regardless of the facts of a particular case, that will be a question of interpretation rather than application. Quite amusingly, the Wiltshire Council case was one in which the Secretary of State was required to give his views in terms of policy, despite the fact, if I recall correctly, he wasn't defending the challenge, and was then told, well, you know, you've got it wrong anyway. Seems slightly harsh thing for the court to have requested in that case. In terms of some general principles of interpretation, well, the first four of these are quite heavy, quite high level, and maybe not particularly useful in terms of actually resolving what a policy will mean, but they give a guide as to how a court would approach these questions. Firstly, avoid over-legalism. The courts have repeatedly stressed that you shouldn't take an overly legalistic approach to the interpretation of policy. It's not like interpreting a statute or a contract. These are policy documents, not primarily legal ones. Related to the second point, that over-interpretation may lead to the wrong interpretation. That came out of the Braintree case, which was about isolated dwellings. Avoid overcomplication and quasi-mathematical concepts, given that planning is a flexible process, and that was a point made by the Court of Appeal in the Staffordshire case, which I've already mentioned. Policy exists to shape practical decision-making. We're not here dealing with arcane and theoretical issues. We're dealing with the issue of, well, should planning permission be granted? That comes out of the Canterbury case. What about if a policy uses a term which is defined in legislation? Do you use that legislative meaning, or do you have, or do you ignore that legislative definition when you're interpreting policy? Well, the answer, unfortunately, is it depends. In the Ford and Holdings case, there was a question of the interpretation of Greenbelt policy, which referred to development. There, the judge said, well, development must be meaning development for the purposes of Section 55 of the Town and Country Planning Act, so either operational development or material change of use. There, the legislative meaning was incorporated into the meaning of policy. By contrast, the Aston case concerned whether major development in the Npbf in relation to areas of outstanding natural beauty, whether major development, that meant the phrase as per the definition in the Development Management Procedure Order. And the High Court said no, the major development in the AO and B policy is a matter of judgment. It's not it doesn't just mean we'll take the definition of the DMPO, that is referring to something else. Now, the Aston case related to the first version of the Npbf from 2012. That precise point has now been cleared up in the text of the Npbf itself in the 2018 and 2019 versions. But the principle still applies, that just because a term is defined in statute doesn't mean it necessarily is useful for the interpretation of the framework. So some lessons in terms of development plan policy. Well, what you're actually interpreting is the policy text. It's the policy text which contains the policy requirements. The supporting text or reason justification doesn't contain policy requirements, although it can be relevant to the interpretation of it. So do bear in mind the supporting text or reason justification when you're interpreting the policy, but remember it's the policy itself which contains the requirements. You might just bear in mind, well, was this policy obviously attempting to achieve something in national policy? Luke mentioned how local policies on heritage are likely essentially to be driven by the contents of the Npbf. Was the policy seeking to achieve one of the objectives or strategic aims of the plan? Policy has to be interpreted, policy documents have to be interpreted as a whole, and so that may require looking at, well, what was this policy aiming to achieve? Fourthly, you want to avoid forensic archaeology. What's this phrase mean? It sounds a bit like a combination of the TV shows The Dig and NCI. It's about saying, well, the policy means what it says, and the interpretation is of the policy document. You shouldn't be digging around, I think that might be the archaeology reference, you shouldn't be digging around in, well, what did the inspectors report into the development plan say? Well, what was the Greenbelt evidence base which went into the policy? You shouldn't be using that material to interpret the policy unless it's clearly ambiguous or those documents are referred to in the text of the policy itself. These are public documents, and so you should be able to interpret them on the basis of what they themselves say. Final point, very obvious, very useful, don't forget the glossary. Interpreting the Npbf, well, in terms of some naked self-promotion here, here are some sources which will help within the interpretation of the Npbf. There's a well-established body of case law on the interpretation of the Npbf. I'm the editor of the first two of those and the author of the third. I apologise for that. I hope someone finds them useful though. But in terms of some general principles beyond or some specific issues, well, there are well-established principles, for example, in relation to the presumption in favour of sustainable development. That's the Monkhill case in the High Court, which has a list of, I think, 15 propositions for the interpretation of paragraphs 10 and 11 of the Npbf, and they were upheld by the Court of Appeal. They're worth being aware of. Gladman says, well, when you're doing the tilted balance in paragraph 11, D, numeral 2 of the Npbf, that doesn't mean that you just jettison the local plan policies and forget about them. For instance, retail, the Asda stores case, on when there'll be significant adverse impact on a town centre, development should be refused. What does that mean? Well, it doesn't mean a presumption against development. It means something to weigh in the balance. In terms of greenbelt, well-established case, the Redtail Aerodrome case, when you're carrying out the very special circumstances exercise and you have to weigh in the balance any other harm that caused by the development other than harm caused by reason of inappropriateness, that's any other harm at all, not just any other harm to the greenbelt. And then valued landscape, and these are just examples of the way the Npbf has been interpreted. Valued landscapes, the Seg Land Promotion case says, well, that's all a matter of judgment. You don't have to have a designation in order for a landscape to be valued. Very quickly, some practical tips. Do you have to give a concluded view on the point of interpretation? If you don't, if it's not necessary, it might be a hostage to fortune to give one. If it's something which totally legitimately can be avoided, it might be worth not saying it. Secondly, if you're giving a view on the merit, if you're giving a view on a point of interpretation of policy, but actually you would give the same answer overall on the merits of the application, even if you reached a different interpretation, if that's genuinely your view, it's probably worth saying so, because then if someone tries to bring an interpretation challenge in the courts, it will be easier to defend that and say, well, it wouldn't have made any difference. Thirdly, we've already touched on this, look at the wording of the policy, that's the starting point, and also think about how does it fit with the apparent purpose of the policy. I think, well, could you explain your interpretation to a judge? If not, that might suggest that it's either too complicated or doesn't fit very well with the wording. Does the planning practice guidance provide any insight into interpretation? And finally, although interpretation is a matter of law, not a matter of practice, you may want to consider, well, has my authority previously interpreted this policy? If so, what did they say and do I agree with it? If not, should I really be making clear that I disagree with that previous interpretation? So that's a blast through some ideas for the interpretation of policy. I'll now hand back over to Heather, because she's going to take a lead on the Q&A.
Well, thank you all very much. Now we will take just 5 minutes or so to answer the questions that have come in. Before we turn to the Q&A though, you should all shortly see a poll pop up. We'd like to know which topic you'd be most interested in if we were to run a further webinar in this series. So if you are still here and you could respond please whilst we're dealing with the questions, then we'd find that very helpful. Luke, I'm going to kick off with a question for you that's come in, which is, what is your view about subdividing harm beyond the categories of substantial and less than substantial? The High Court has said, I can't remember the case name, but the High Court has said that harm shouldn't be further subdivided beyond those two categories, but in practice it often is. So we've been asked for your view on that.
Sure. I mean, the short answer to that point is that the three categories exist for the purposes of deciding which test you're going to apply. But when you're applying that test, where exactly the harm falls on the spectrum of less than substantial harm, say, is going to be absolutely essential to how the balance resolves. You know, you're in a less than substantial harm case, you are saying, you know, giving great weight to the harm, is it outweighed by the public benefits? That's the test you apply, and that's true for all less than substantial harm cases. But whether or not the public benefits outweigh the harms is going to look very different if the harm is minimal to if the harm is so serious it only just isn't substantial. And it's worth stressing that the Bramshill case I mentioned from 2 weeks ago makes very clear in this, that in identifying where in the spectrum the harm falls, the courts will give the conventional respect to the planner's judgment and the fact-sensitive decision-making that's conducted by the council or the inspector. So that the short answer is yes, it is not just important, but vital to work out where within the spectrum the harm falls. The PPG encourages you to describe that in your reports, and you can't conduct the balance without doing so. The three categories of harm, just to reiterate, are about deciding what type of balance you're going to have to conduct. I hope that's helpful.
Great, thanks, Luke. Alistair, one for you. A query whether challenges on the basis of interpretation are often successful in your experience.
That's a really good question, which I shall answer now. I'm unmuted. You'd have thought that, again, you'd have thought that was something I'd have picked up over the last year, the ability to unmute myself on Zoom. Apparently not. Anyway, how often are interpretation challenges successful? Well, Lord Justice Lindblom, I can't remember where it was he said this, because Lord Justice Lindblom has dealt with a lot of cases on the interpretation of the NPBF. He said there are lots of cases on the interpretation of the NPBF. Sometimes, but not very often, they're successful, and sometimes the interpretation is material to the answer to the matter in question. I think that's a broad summary of what he said. My general feeling over the years of looking at decisions, particularly those interpreting the NPBF, is that generally speaking, the courts will take an interpretation of policy which preserves the judgment of the decision maker. That's a really broad across the view approach, and obviously there are some circumstances where the interpretation of policy raises some quite specific issues, and sometimes the courts have given quite specific answers. But generally speaking, the courts, when they interpret policy, and will be seeking to preserve the judgment of the decision maker. That is the general trend, and as a result, whilst interpretation questions are important as a matter of number, generally speaking, in terms of those which reach a final decision in the courts, they're far from certain to be successful. Even if you can identify a question which is one of a matter of law, which is an interpretation of policy question, that doesn't mean that the challenge is going to succeed, and indeed very often they don't.
Thanks, Alistair. Kim, coming back to what you were telling us about Croyd in particular, questions come in. Do the Thornton Hall, which is the Court of Appeal decision, and the Croyd cases mean that the 6-week limit for planning JRs is now toothless?
I don't think so. I mean, they're two decisions relatively shortly, one after the other, where the court has significantly extended the 6-week period. It's 6.5 years in Croyd and 5 years in Thornton Hall. But they're both decisions that are very unusual in terms of their facts, and they're cases which were very exceptional. So in Thornton Hall, you had a decision where the planning permission was supposed to be temporary for 5 years and was actually granted permanently. So it was only discovered after 5 years that mistake had been made. And similarly in Croyd, well, because until the lawful development certificate was refused and then was then granted on appeal, it wasn't sure. No one really thought that this permission actually did what it turned out it did. So they're very unusual facts, and the courts in both cases were clear to say that these were decisions on those unusual facts and on the exceptional circumstances that arose in those cases. So I don't think this opens the door to challenges left, right and centre about extending the 6-week period. And also to reiterate that even in those cases where there has been exceptional circumstances and a reason for some long delay, the courts are keen to emphasise that you still need to be quick when you discover that there's a basis for challenge. Even if it has been 6 years, it doesn't mean that then taking 8 weeks is going to be allowed over 6. You know, you've got to still be prompt once those facts come to light.
Yeah, we've got 2 questions left, so I think we'll try and do both of them. Luke, coming back to you on heritage. We've been asked, when assessing harm to multiple heritage assets, which is often the factual situation, as you'll know, do you group the assets together and then conduct the paragraph 195, 196 balance against all of the harm, or do you have to conduct an individual balancing exercise for each heritage assessment?
Well, this is one of those issues that has a strict answer and a practical answer. I mean, the strict answer is that the balance needs to be conducted individually for each asset. In practice, it may be that the factors are going to be very similar for some of the assets. So, you know, it's not uncommon to get clumps of listed buildings, for instance. You get a listed church next to its listed mews house. Their significance is going to be derived from similar sources, and the impact of the development on them is going to be similar as well. So in that sense, when you're conducting your balance, it can make sense to look at those 2 assets together. That's essentially a matter of planning judgment, as Lord Justice Lindblom made clear in the Bramshill case. Where you have to be really careful is where you have some assets which are substantially harmed and some which are less than substantially harmed. What you can't do is say, well, I've got 15 less than substantial and 1 substantial, so I'm going to do it in the round under paragraph 196 as a less than substantial harm case. Such an approach would be fairly clearly vulnerable to legal challenge. So you've got to look at the nature of the harm, the nature of the significance of the assets, and come up with an approach which captures all of them. As I say, sometimes that can involve a lot of overlap. Other times the impacts can involve no overlap at all, and the exercises are much more easily carried out as distinct ones. Fact sensitive, but make sure you're not giving weight to any individual asset. Thanks, Heather.
Thanks, Luke. Alistair, on interpretation of policy, the question is, if someone brings a judicial review that alleges a misinterpretation of policy, does the local planning authority have to file evidence in relation to it?
The short answer, I would say, is no, because the interpretation of policy is a matter of law, not a matter of opinion on the part of the decision maker. That said, there is one weird case or aspect of a case which I find quite weird from 2018, which is a case called Good Energy Generation, I think, against Secretary of State, Communities and Local Government. There was the Secretary of State, it was a matter of the interpretation of the Npbf, the Secretary of State put in a witness statement saying this is the meaning of the policy and this is how it was applied in this case, essentially, or this is how it relates to a situation like this. The second of those, dealing specifically with the interpretation policy, was found not to be germane as that sort of retrospective reasoning, which the courts don't like. However, Mr. Justice Lang did seem to find the interpretation, generally how does this policy work and how should it be interpreted, that part of the witness statement was admitted and considered by her. As I say, I find that strange and difficult to fit with the fact that it should be a matter of legal submission. So what do the lawyers say policy means rather than a matter of evidence? Subject to that slightly strange case, I would say that no evidence doesn't generally need to be provided. One possible exception to that would be if the decision maker is trying to say, well, the decision would have been the same in any event, and relying on the amendments to section 31 of the Senior Courts Act, and say, well, it's highly likely that we'd have reached the same decision in any event. That might be clear from the officer report itself. If it's not, for one reason or another, then there is case law decision of Mrs. Justice Lang, which suggests that if a public authority is trying to rely on the fact that a decision is highly likely to be the same in any event, then that should be supported by witness evidence. So that might be a circumstance in terms of when you would want witness statements, but that would be about what I would have decided rather than this is what I think it means. So even so, in terms of the general principle, in terms of what policy means, no, it's not a matter of witness evidence.
Thanks, Alistair. We've had one final question that snuck in actually on heritage again, Luke, so I'll come back to you on that. And the question is, in terms of defining substantial harm, Historic England have asserted that the Bedford case and the definition there is not relevant now, and that the advice in the PPG should be used instead. And the specific query is, how relevant has Bedford been considered in recent appeals and High Court challenges?
Thanks very much. Any time you hear an assertion that a judgment of the High Court on exactly the language in policy has ceased to be relevant, I suggest a degree of caution is needed. Bedford is, to my knowledge, the only case at High Court level to have considered what substantial harm actually means in this way. It's still applied on a regular basis in appeal decisions. And I would suggest that the approach taken in the PPG to what substantial harm means isn't actually that different to Bedford. What they both recognise is that what substantial harm is about is the total destruction or almost complete loss of the significance of the asset. This takes us right back to where I started in my talk about identifying what the focal point is of policy and law here. It's not about the loss of the asset, it's about the loss of its significance. You could have a listed building that's got a big modern extension on it. That modern extension could be completely knocked down. You could be destroying half of the physical building. But if all of the significance flows from the old bit and the old bit's not affected, then it may not cause any harm at all. The destruction of the fabric isn't a destruction of the significance. Similarly, something which looks quite minor in physical terms could have a massive impact on significance. So I don't accept, and I would caution against treating Bedford as being legally irrelevant now. And I also think my own view is that when you look at the PPG with one hand and Bedford on the other, through the prism of significance as being the test, you actually find there's not a great deal of difference there. What they're both clear on, though, is that this is ultimately a matter of planning judgment. And if you consider all the factors and judge that harm is substantial or is less than substantial, then it would be a very, very difficult thing, I think, for anyone to challenge and overturn that judgment in the High Court. It have to be established that your assessment of substantiality was public law irrational. And in this context, that's a very high hurdle indeed. Hope that's helpful. Thanks.
Thanks, Luke. Yeah, I mean, I'd add in my experience, people are still relying on Bedford on appeal, certainly. So I would agree with your assessment, I think, on that. The results are in from our poll. We have Roundup on Npbf and Tilted Balance leading the way in terms of things that people would be interested in hearing about further. So we'll put our thinking caps on in relation to that. That's everything from us, I was going to say this morning, but we've slightly edged into this afternoon. So thank you all for joining. I hope it was useful and have a good rest of the week.